So,
May I,
before
also,
we do that, oh no, the minutes are next, sorry, I was gonna do the minutes.
may I suggest I first follow up on the request that was made in our last meeting? And that was that we bring an example of an order where we addressed public comments. And so I brought copies of docket 7970, which is the Vermont Gas Pipeline order. I'll point out that I was not on this case. This was decided by the former board, so I don't have direct experience with it, but this was issued in December of 2013, and we've copied the pages. There's from page 23 to 31 that summarizes and digests and does some self-reflection on the public comments. So we pass this out, and I believe, Judge Mello, you've received one by email from Andrea.
Bob, did you get one of the dockets from Andrea?
I did, yeah.
Okay, 7970. Docket number 7970.
So I'm just delivering that as requested. And we also brought, also as requested, a fresh draft of the recommendations.
Yeah.
Yep.
So
Can you pull one off for me?
we have, here you go.
Can I have one before you?
First, before I pass,
Thank you.
talk about it, I have, for members of the public, there are highlights on limited number of copies, and I also, if we run out of those, and I'll need one. If we run out of those, we have somewhere the yellow doesn't show up, but you can still see what's highlighted there. And what we've done here, you can see the key on the front page. The recommendations in italics are steps already being undertaken by the board, and remind you that one of the most significant ones is the theme of PSB, which will have all kinds of really meaningful changes in terms of making it easier for citizens to participate. So those are in italics. There are other recommendations that are preceded by 3 asterisks, and that means that in order to implement those, we need statutory changes. And then the recommendations highlighted in yellow, as we did last time, they just highlight the recommendations that mirror the process or the spirit of what's currently done in that teaching. The other thing we did was reorganize the recommendations. As you can see on page 1, at an attempt at thematic organization. So I don't need to read that, you can see that for yourselves. And we've added some of the recommendations the recommendations that were made at the last meeting as well from Judge Mello and Senator Burns.
Thank you. Okay, this is fabulous. Thank you for all the hard work that you put into it.
And also Andrea and you should.
Well, I mean, that's my I think that it might be appropriate, let me just ask one question. Are there any things that are in the document that we had previously that are not included in this document?
No,
Okay.
but there are some additions.
And then there are the additions. I think Judge Mello had some suggestions, and I made some suggestions based on Charles Storrow's comments and information from last meeting.
Yeah, so what we did, you can see, for example, on page 11, we bracketed the 2 bullets at the end with Judge Mello's name to point out that those were from him. And then, did we highlight the Chuck Storrow ones? They come,
Yes.
they're on what page? Page 4. Yeah, so we called those Senator Lyons for your request. And then the one that is a new element.
So my suggestion is that we take some time to go through the full document and to understand what it is that we have here, and to look for any redundancies or things that we think should be changed, wording, concerns. And I think we should probably start with the ones that were not included last time, so we'll go to the back of the document for, yeah, work forward, how about that? Judge Mellows and then Chuck Storo's, and my suggestions.
And one more thing I would add is that we did include some language to introduce each section, but I think that what we need to do before this is finalized is also, I would suggest, an introductory overarching paragraph about things that apply to across the board. For example, the significance of PSB, why that matters. And, yes.
Madam Chair, I will have some comments on some of the recommendations. We've gotten a chance to really review them, some of the ones that were already in here, but we'll hit them if we start at the back and work forward.
Well, I'm aware of Judge Mello's schedule. I mean, he's not here for the whole time, so let's start with his, and then we'll go back to the beginning, because I see he also has some that are in the beginning. So let's start at the back of the document with
Page 11.
page 11, and then we'll go to the front of the document and go through.
You know, since these both reflect the department's role, I just would say we have no objection to either of these. The only thing I'm a little concerned about is on the first bullet, just understand that sometimes we get robo emails, I'll describe it that way, where it's the same comment from multiple people sent out through organizations or sent out through a mail list. And I'm not frankly sure how to handle those. It's been hard to think about how to respond to this. We do typically respond to all unique emails and letters already, and so there's no problem with that. It's just that when you get 250 of the same thing, I don't really know how to handle that.
I'm very sympathetic to that, because legislators get the same kind of emails from organizations or groups, and so.
How do you guys handle that?
It's difficult. I mean, some people absolutely ignore them, others go through and reply to all of them, but I don't know that we really want to tie administrative departments up with that kind of individual response.
Maybe, Judge Mello, do you have a reaction to this? Because this is your recommendation. I was thinking maybe have the department respond to all relevant communications, or some, I don't know, some other word there.
Individual responses.
Well, they all are individual response, really.
What you said, you
So-
sometimes get robo.
I do, but it comes from individuals.
Yes,
It
it
comes from
does.
250 of them in the same task.
So, one possibility, I see your hand up, you have your hand up, but one possibility is to have an online response. And so if there's a letter that's coming in that's the same, one online response to that.
I'm trying to think, and I think, Judge Miller, we need to hear from you, but I'm thinking about the spirit of your recommendation. It is that the department be responsive, and that there be a sense that the comments aren't just going into a black hole. And yet at the same time, as you're saying, I think that often sticking literally to a recommendation can undermine the effectiveness of the larger work that is being done too. I mean, as you can see, to a sort of absurd degree in the legislature, you could spend your entire time responding to the emails that you get rather than, engaging in policy discussions in your committee room. So I think that one can't be literal about some of these, about this recommendation, and I think it would need a full-time staffer.
Did did you have a comment?
Yeah, speaking as someone who's been on both ends of this type of correspondence, both as someone who handled constituent correspondence at the administrative level and as someone who's organized these, as you would say, I think that they do dignify a response. I think that they all should have some sort of response. And I know that there are tools available to the administration to actually facilitate a response to over 250 people who sent the same thing at once. I don't see any reason why it's impossible or timely. In fact, it's frankly a little easier because you can give the same response to all, say, 250 individuals.
All right, well, thank you. You know what, I'm just gonna kind of set the table on this one, but it's opportunities now for this group to make some decisions on recommendations, understanding that everyone sitting here would love to be diving into each. So we'll hold off comments till the end, I think, but I do appreciate what you're saying, and of course, there must be software or email adaptations that can be made.
Well, like I said, I just wanted
I get it.
to say, because as I worked, when I worked for the state, I knew that this was available.
Sure.
In fact, used it, so.
Okay, something to think about. Judge Mello,
Yes,
so you are the one who suggested having a response to all communications from members of the public, and you've heard the concerns expressed about sort of the robo email, and then we've had a comment that it's possible to respond. Do we leave it as it's worded or make changes? What are your thoughts?
well, I understand that the robo emails or postcards, it shouldn't be necessary to have a different response to each of them. But you can have a robo response, I suppose, to a robo email. It just seems like common courtesy and respect to the public, who's bothered to take a position to get a response. I'm not suggesting in what I put here that it has to be a terribly long and substantive response, but it seems to me there ought to be a response.
Okay. Tony?
Simply acknowledge receipt of the,
Hmm?
they can acknowledge the receipt of the communication.
Right, thank you for your communication. Okay. So I think we should leave it in. Anything else on that last page? The advocacy bullet, is there any comment on that, Commissioner Recchia?
The second bullet?
Yeah.
No, that's fine.
Okay. All right, so, thank you. So let's go back to page 1. And actually page 2. And walk through, and remembering that yellow is Act 250.
Act 250,
Like, Act 250 light. And the 3 bullets with 3 stars are statutory changes.
in italics currently underway, but not meaning that they've always been in place. They're recent.
Okay. In process or what? Okay.
Either recent or in process.
All right, so, who wants to walk us through these? How are we gonna do this? I know we've read through all of them.
I think we should ask if people just have any comments on them, otherwise, we leave them the way they are, 'cause otherwise, I don't think we need to.
Right, okay.
Yes, most of these, you've already seen, there's been mostly reorganizing.
Okay, page 2, introductory paragraph, and,
Oh, yes.
Can I make a recommendation though on, I'm sorry, where were you?
I was on the introductory paragraph.
Oh, very good, do that, that's before mine, definitely.
And thank you for saying that, because actually that's also new.
It is.
Only introductory paragraphs.
So let's put ourselves there first, and then
Okay.
we'll hit each of the bullets as we go ahead. All right, and council, you will help us with this as well, right?
Absolutely.
These recommendations, I'm gonna read the paragraph out loud. These recommendations make it easier for citizens to participate in all types of PSB hearings. They also change the way the board provides notice of pre-hearing conferences and public hearings so that citizens are better informed of upcoming hearings. All right. And let's make sure that this all sort of coincides with being said. Now, and the one question I have is, okay. First bullet, first dark bullet. And anything on the open bullets there?
Some of these things may seem minor, but for example, allowing people to attend conferences by telephone makes a significant difference, I think, in people's lives. There are a couple of the I think, very substantive things here. I think that we've lost, as I've said before, the ability for people to attend statewide when we lost Vermont Interactive Television. And so I think that's an important one. And another one I think is very important is the second to last bullet, where there's actually an informational session before every public hearing.
And that's
so
the only
people-
place that I had suggested, I would eliminate an hour and just start before the board's
Yeah.
public hearing, because sometimes it
Maybe
might be,
more.
yep, it might be a complicated case, and you might do it the night
Right,
before,
I
you
agree
might do
with
it
that.
2 hours before and take a dinner break, I don't know, so that's my only suggestion on this.
So is there a change there? Or
We
Yeah.
delete the words an hour.
Okay. Well, is there an at least we want?
No, because sometimes it would be right before the board's
Okay.
public hearing, but it's be flexible.
Do we want to say anything in the public hearing section with the 3 bullets? It says VIT or an alternative. Do we want to acknowledge the PEG channels, the PEG groups?
I'm not sure it's necessary.
Such
I'm not-
as, I think that because they were so forthcoming and wanting to participate, I think that we should mention them. But,
No objection, except for we should acknowledge, well, we don't need to acknowledge, but it is only a one-way, I believe PEG
Yeah,
is
it's
only a
one-
one-way, like, visual and audio.
Right.
Whereas Vermont Interactive Television was
It's
truly
interactive.
interactive, right?
Yeah, they're quite different.
They are very.
Yeah, they
I
are.
mean, PEG would be basically broadcasting a hearing,
Mhm.
and VIT allowed participation by the public wherever they were based.
Right.
And in real time, and it was back and forth. That's been a significant loss.
okay, so but PEG could put together a call-in.
Yeah, and that's why we said develop an alternative, because I got the sense that there are possibly other ways to do this that are actually available for other entities, and so that leaves it open. And I was just given a note that telephone may not be the only way to do the highlighted one, but by
Right. Skype.
Right.
video conferencing.
Okay.
Bringing us into the 21st century.
Right. By telephone or
Or-
other electronic means?
Yeah. That's right, in 2 years, we may not have video conferencing, we'll have something else like.
We'll have a chip in our brain. to be able to do that.
Did we decide at
Drones.
least an hour before or just before?
I think we decided just
Before.
before.
Oh, okay.
Yeah.
Okay, and the last comment is Judge Mello's one public hearing in cases with significant public interest, even if not statutory.
And I would say that, point out that we added the language, even if not statutorily required, because there are cases in which a public hearing is required. But I think the spirit of this is that even if not legally required, that that we do it anyway if it's a significant public interest.
Do we have to define significant?
I think you know it when you see it.
Greater than two?
Anything by which I get a robo.
That's when you get the robo message.
Right.
That's right.
I mean, how do you do?
I know.
I don't
Can I
know.
comment on this?
Yep,
So, thank you for including the bullet, but it left out some of the wording I had in my recommendation. What I suggested was to say that in cases of significant public interest, the PSB should hold hearings at times and places convenient to the public and in locations relevant to the petition. That language was excluded for some reason.
so there's no other geographic places?
We have some of that in the earlier parts of this. Let's see, the next section talks about having hearings in different areas of the state.
Yeah, so that was a different category. Yeah, in category 2, is meant to get at the geographic challenge. So the VIT suggestion we put in 2 categories. We put it in category 1 because that helps citizens participate in hearings generally. We also repeated it in category 2 because that addresses geographic constraints. And so the geographic part of that recommendation appears in, where is it?
It's on page 4.
Yeah, the second bullet,
That's more site visits, but is there any place here
It says,
in the area where the project is proposed?
yeah,
So
but it
it's a
says
combination.
evidentiary hearings.
you know,
so
we
it
could,
says-
what we could do,
I think we should put it on the other page too.
What are we envisioning? What type of project that would have significant public interest wouldn't already have built into the process of public hearing or two? So that's my only.
you mean, wouldn't have one already statutorily required?
Yes.
Could we ask, or,
I frankly struggle with the same thing. The only thing I can think of is maybe when Fairpoint, right, when Fairpoint was acquired by, so when Fairpoint acquired Verizon's assets, but I think even under 231, there's a public hearing requirement. I think your question is well taken, Representative Klein, but what the recommendation accomplishes is it removes any possibility of missing on the point.
I'm sorry, I didn't understand that. That's
Well, what I mean is that if you make this recommendation, it's a commitment to hold the public hearing period when there's a case of significant
And
interest. And then we don't have to search for.
Public hearings are great, but I've been to a number of public hearings where nobody showed up.
I've been to a couple of those recently.
And that gets to be expensive and unnecessary.
This is true.
and we already do it when,
And you want to have the public hearing when there is an actual cry or a significant, but to just have it built into, every project that comes down the pike will have a public hearing regardless of whether anybody wants it or not.
Well, that's why I limited it to cases of significant public interest.
And
Do you have a definition for significant?
We could grapple with that, but I don't. And if the legislature decides that they should include this in legislation, they don't need to do that. But it certainly is not going to be a public hearing in every case. Only those where there's a significant public interest. And that would be where an awful lot of people are going to be impacted impacted in a significant way. I mean, there are lots of ways to define it, I suppose. I don't think we need to get to that level of detail, though.
Would it be helpful for June to point out the actual requirement for public hearing?
Yes.
Judge, June Tierney here. Section 248, which is where I think some of the more significant public interest cases occur, already requires a public hearing to be held in such cases. So,
Good.
so I don't know that, I mean, this is the point I think that Representative Klein is making, is as I sit here trying to find an example of what illustrates something new that we would be doing, I'm having a hard time coming up with a case like that. The fact is the board holds a public hearing in cases of significant public interest. I'm happy to be corrected by anybody if they can think of an example where the board's not done that. And the other point that Representative Klein's making, there is some value to that point. There are any number of public hearings that we convene where folks do not show. And personally, I'm happy to show up every time, but I've been searching for 15 years for ways to grow public interest in attending these hearings, and I've not had much success so far.
So I'd like to make a suggestion that, without, not to take this out, but rather to add a simple phrase before hold, and just to say, continue to hold.
Yes.
So continue to hold at least one public hearing in case, so that there's an acknowledgement that it's happening and it should continue to happen. All right.
We'll italicize
Well,
that.
but I think we should add, though, that the hearing should be at times and places convenient to the public and in locations relevant to the petition.
I'm okay with putting that in here.
Fine with that, Tony?
Yeah, so why don't we just add that,
Can you say that one more time, Judge Mello?
we have
Yes, in cases of significant public interest, the PSB should hold public hearings at times and places convenient to the public and in locations relevant to the petition. So if the petition involves a development of some sort on Mount Snow, the public hearing shouldn't be in Montpelier.
Isn't there a requirement in the 248 statute?
That it be in the county, at least one of the counties that are affected by the project.
And also for any transmission project, be it,
Right.
be it wires or pipeline, to actually hold a hearing, a meeting in each of the towns.
Right, so we would, again, that would continue to
Yeah.
apply to that.
Yep.
I think it's fine. Good. And then continue to provide every member of the public who attends the public hearing and is not a party to the case an opportunity to speak at the public hearing. This was Judge Mello's suggestion. The italics means that it's currently being implemented by the board, so there's no need to take this out. I think it's important to leave it in. Okay. Can you help us with the evidentiary hearings so these first two open bullets are in italics. This means that you are doing this.
That's right, and a lot of the changes that are coming are incorporated in the new net metering rule, which is almost finalized. We're having a public hearing on it tomorrow morning, and then it will be going to LCARD.
Oh, good.
But that is one of the things, the new net metering rule actually incorporates a lot of the spirit of this, both in terms of this as an example, but also the creation of documents, templates, plain English instructions, things like that. So they'll first see the light of day in the new net metering rule.
Isn't it, so, in terms of mentioning the specific net metering rule, is that important to have here?
I think it is, because it covers a broad swath of energy projects. In fact, the most frequent petitions and applications are net metering. So that's a significant category.
Okay, any other comments on that page?
Remember, by evidentiary hearings, we mean this is where the judicial is in the process.
I do have one other comment, if I may.
Yep.
One of my other recommendations was that members of the public should have the right to attend all PSB hearings, both public hearings and technical hearings. And I didn't see that in here. Did I miss it?
Sorry, I wasn't listening.
Can you ask that question again?
Sure. One of my recommendations was that members of the public should have the right to attend all PSB hearings, both public hearings and technical hearings.
What they currently do.
I didn't see that in here. Did I miss it?
Well, that's what is currently the case. They can attend any of those.
Is that a statutory requirement, or is it?
They're open meetings.
They're open meetings.
They can't say.
I wouldn't go that far.
No.
Okay.
The reason why I recommended it is because some parties had to file a lawsuit in federal court to get the opportunity to attend a hearing.
If I may,
We should just state it somewhere that the public has the right to attend all hearings.
Judge, if I may address that for a moment, the public has the right to attend hearings the way the public has the right to come to your courtroom. And even the public does not have an uninhibited right to come to your courtroom. There are circumstances under which you as a judge are able to limit them, and the decision that was rendered in the case you just referenced made clear that those circumstances had not been satisfied in the case that the board dealt with this summer, but the decision did not hold that under the right circumstances, the courtroom could not be closed. So what you are saying is that the board, under no circumstances, would be able to close the hearing room. And that's inconsistent with the board's role as an agency that has the powers of the court. And there is, to my knowledge, there is no precedent for the board having closed hearings. It's not the board's culture at all. But I would not want to take that one case from this summer and treat that as representative of a condition that requires this kind of remedy.
Are you objecting to the legislature enacting a statute saying members of the public have the right to attend all PSB hearings?
I would suggest that the legislature would need to reconcile that with having also said that the board has the powers and responsibilities of court. The board does have a responsibility to provide a forum in which the litigants can exercise their due process rights, and it is not inconceivable that public attendance can interfere with that.
Well, one of the big differences between the PSB and other quasi-judicial agencies and the courts is that the PSB and other agencies make decisions based on an assessment of the public interest. We don't do that hardly ever in court. So in deciding whether something is or isn't in the public interest, it seems to me that the public should have a clear right to attend the hearings.
Indeed.
And so if they're disruptive, of course the board should have the ability to deal with that.
But you will just enacted a right for them to be there. The implication of what you're saying is that the board does not have the right to eject those people.
I don't think the board should have the right to eject the public from a hearing.
Then I cannot
Unless
recommend.
they're being disruptive.
Understood. And I think at this point I've said as much as I should say, and the committee really ought to take over the discussion.
So I think the key is, unless they're being disruptive, is the piece that was, I mean, that's what prompted this summer's action by the board. And, you know, well, without saying whether I would agree agree or disagree with how they chose to do that. They did choose to limit public participation because of that disruption. So that is why they did that. But to my knowledge, they've never done that or needed to do that before. And all public hearings and, technical hearings as well as any other proceedings are open to the public to come and listen.
With the minor exception of confidentiality.
With the exception
when
of
there's confidential
confidential
testimony.
information, right?
Also, since that was an evidentiary hearing, it would not have been possible for a non-party to participate, but rather to observe.
Okay, so I'm letting you continue the discussion. Judge Mello, what are your thoughts after listening to the comments that have been made?
Well, I haven't heard any comments suggesting that the public shouldn't have the right to attend hearings.
You're not suggesting unlimited attendance. The concern is about demonstrations in the quasi-judicial process.
Yeah, as long as they're not disruptive, and there should be an exception, I agree, if there's confidential information, that needs to be protected, that's fine, but
So,
people should have the right to be at the hearings unless there's a good reason for them not to be there.
Which again is currently the case.
how do we say that? Continue to allow public attendance at all hearings,
Yeah, I'm not sure allow is,
or public has the right to participate, to
continue to,
attend.
To open the hearings to the public?
Provide for something like that.
Open hearing.
Have the right to continue to attend.
Mhm.
Continue to have a right to attend?
Well, but
Yeah.
are there rules, are there public service board rules regarding,
how about,
regarding confidentiality and those issues that would preclude attendance?
There is the
In accordance with the.
there is no rule per se, there is the practice pursuant to which when information that has been ruled to be confidential is going to be discussed in the hearing room, that folks who have not become signatories to the agreement governing that sort of information must clear the room. And the folks who can remain in the room to hear that that information spoken about are limited.
So it's board practice.
It's board practice that is based on law that, common law that deals with the rights of individuals to have certain kinds of information protected from public view, if it has in fact been found to be entitled to such protection.
Okay? And then what is the practice around disruption?
That's a very good question, Senator. Quite frankly, the board has next to no experience with that. This one case that we're discussing is the only one I can think of where the board has had to contend with these circumstances, and I would hesitate to say that how the board has handled those cases is representative of a practice or a rule. It is the record of acts that were taken in dealing with circumstances that are highly unusual for this board.
So I guess
But I would point out too that those actions were taken against the backdrop of both state case law and constitutional law.
right.
perhaps it's continue to open hearings to the public?
Right. Continue to open hearings to the public. Judge Mello, would that work for you?
Sure, whatever language meets all these interests is fine with me. I just think that there ought to be a clear statement somewhere that PSB hearings are open to the public.
Okay, we'll look for the right place to insert that.
Right, okay, yeah. All
I
right,
just have one other recommendation that I had that I didn't see included in the latest version of the list. And it was my recommendation number 4. In cases of significant public interest, the PSB should include in its final decision a discussion of the comments that are received from members of the public, together with an explanation of why the PSB concluded that the views offered by members of the public are or are not in the public interest. You did include number 6, which related to the DPS, but this was number 4 related to the PSB.
yeah.
We brought that example of how we already do that, so we could do, this was what we handed out, and I believe we had emailed to you, in docket 7970, a very long section of the order devoted to just that. So that is something that we do if,
Great.
if people want, we could say continue to do that, but it is not something that we do not currently do.
On page 8, there's a bullet, the third from the bottom, that it says, address public concerns in a separate section in the final order, so it is clear to citizens what issues were raised in public comments and why the board reached the decisions it did regarding those issues.
What page are you on?
Page
8.
Third bullet up. Yeah.
Yes, there. It's on page 8, third bullet from the bottom.
Yeah, good. I didn't realize it was already there before.
Yeah, the wording
Thank
was
you.
a little bit different. We reworded it from last time.
Okay, so
Thank you.
anything further, thank you, on page 3.
Yeah.
Uh-oh, go ahead.
No, it's not really an outline, but the last bullet under evidentiary hearings, open bullet, with the MOU, I would suggest that this is probably too restrictive. MOUs are sometimes entered into before the technical hearings, sometimes after. Sometimes they address only one small issue, and sometimes they address the whole issue. I think in the spirit of what's intended here, rather than saying that it be filed 2 weeks before the evidentiary hearing scheduled in the case, because sometimes it's the evidentiary hearing that breaks loose some of the issues and you can resolve it after. That you say, require that parties in any proceedings have adequate opportunities to review any MOU, and at a minimum allow for one round of discovery on the MOU before a hearing, and then also end with allow parties to request a waiver of the requirements. So you're not restricting the time frame in which an MOU could be entered into, but you are giving adequate time. And this is something the board does anyway. If an MOU comes into evidence, then there's a discussion with all the parties about how much time do you need, what do you need to do in order to be able to respond to that. So I think codifying that is helpful, but I would be flexible about when an MOU has to be filed.
So would you repeat your suggestion?
Yeah, and it's not beautiful language, but maybe it'll get us through the next draft. Require that parties in any proceedings have adequate opportunities to review any MOU filed or entered. And at a minimum, allow for one round of discovery on the MOU before a hearing.
Sorry, that.
Speak a little slower.
Require that parties in any proceedings or any proceeding have adequate opportunities to review any MOU filed,
And did you say opportunity or time?
opportunity.
Okay.
We can switch it to time if
Okay.
you want, but
I know, it's hard, if you put time in, it could be 5 years.
right.
To
which,
To review what?
to review any MOU filed, and then I do a comma, which at a minimum should or must include one round of discovery on the MOU before a hearing. And then I make the last sentence that's already there a complete sentence. Parties may request a waiver of this requirement. So I think that gets at the spirit that was intended here without unduly restricting when an MOU
Yeah,
can
2
come
weeks
in.
may not be. Everybody okay with that one?
Yeah.
Sometimes an MOU isn't entered into until like the very end of something, so.
Do you want to include the language or provide that there will be a mandatory opportunity for a waiver hearing? Or
No,
say
I would take that out
Okay.
because I think you're already saying that there'll be discovery and then a hearing.
Good.
It's not including that language.
Well, it doesn't, I don't think that, we'll go back, we'll come to you at the end.
Madam Chair, a thought has occurred to me
Okay.
that the charge of this committee is to present some recommendations to the legislature on pathways for the public to have better access to public service board proceedings. And by the very fact of the requirement and by the very fact that we are going to forward any set of recommendations, certainly no matter how inclusive we try to be, nobody's going to walk away totally satisfied that we covered all the bases. I don't think that we should feel compelled to cover all the bases, because if we are successful and what we turn over to the legislature piques their interest, they would then have to pursue this in
Yeah.
legislative form, in a bill, and then whatever else people want to bring to that table, whether it be the public or the judge or any one of us or anybody else, they more than have the opportunity to help shape that legislation. So I'm just sitting here wondering to be, so hopefully that will be in a timely matter today, that we get out of here before dark.
We're good.
I just, so that we don't get hung up over tiny little details.
I do appreciate what you're saying, but I think the 2 weeks is not insignificant.
No, that was not a tiny little detail
That
for
was
me.
not a
That
tiny
was-
little detail. I mean, if we put this in here, that would,
No, I didn't mean that
No,
particularly.
no, I understand
wasn't
that,
speaking
but there are some
specifically
things.
to that.
if we put some things in here, there's maybe an implication that we've actually taken, thorough testimony on all of this. And the reality is, we probably haven't taken all the testimony that would have to be taken.
And remember that we are also going to forward not only our finished formal recommendation, but the entire body of the work that we have received
There you go.
along with it. So nothing will be lost.
So, thank you, Representative Klein, and you're absolutely right. We don't want to get bogged down. I heard what you said. So, anything further on page 3? All right, we're over on page 4, and recommendations to increase ease of citizen participation in different areas of the state. The recommendations in this section will make it easier for citizens who live far from Montpelier to participate in PSB proceedings regarding projects proposed in their communities. So this is where we pick up that geographic distribution again, Judge Mello. So go through this. or other, yeah. And this is where you have your EPSB footnote.
Yes. But I think that there probably should be, again, that would also be acknowledged as a significant future change in whatever introduction you provide.
Okay, so then the last bullet with the legislative asterisks is a recommendation that we, with a suggestion that we heard from Chuck Storrow about providing municipalities with support. Let's just go to the this doesn't go to the extent, is there another place?
It didn't repeat all of the language from that statute. The second part of it is not relevant to what we're doing here.
So, Madam Chair, I think I know where you're going. This does not include the intervenor funding piece, which
That's
is
right.
later.
That's later.
That does appear
It's
later.
later.
Okay,
We'll talk
we're good.
about that.
Okay, we're good.
And in that case, it was much more specific to certain kinds of interview versus more broad.
Great. Okay.
But this, attending a hearing at the request of a municipality, at least for the second bullet, the department would be fine with it.
Right, and certainly, if and when the legislature would take this up, they would be reviewing that whole section anyway, so. All right. Anything more on page 4? Page 5. Okay, this is instructional documents.
Yeah, so again, it looks like it's minor, who really thinks that these kinds of things are earth-shattering, but just writing things in plain language and making them available, and even going to the extent of just having it be a form that someone can fill out, where before they had to basically reinvent the wheel, and as a non-lawyer usually. This is substantive, including, we discussed 2 weeks ago, the Citizens Guide, that currently is the only compilation of instructions or big picture in how the system works. That would be replaced with something hopefully a lot clearer and helpful. So these are the tools. This is the tools section.
I might recommend that we take out the parenthetical in the second to last bullet. I think that there should be an explanation of the difference between the board and the department, regardless of whether the name is changed or not. So I would suggest we just take that out.
Yeah, I think that's a good point. Even if it's
What are you taking out that discrimination there?
If board name, it says that we should have an explanation of the difference between the board and the department if the board's name is not changed. I think we should have a description of the difference between the board and the department anyway.
I
That's a
agree
good
with
point.
you.
Even if we have very different names, that people still need to
Still,
know
they
what
would
the
still
difference.
need to know. Right.
You're absolutely right.
Okay.
I think that's a pretty major thing.
Yes.
Yep, I think that's a source of constant confusion, including in the legislature.
And including for new commissioners. I mean, Jeff had to beat me up several times to understand.
Okay, any other comments on 5? So the next section are recommendations. In this section will ease citizens' participation in PSB proceedings by providing them easier access to documents and other information about specific cases, as well as guidance documents with information about how they can participate in PSB proceedings.
So unlike the previous section, which is more about providing citizens better tools to use, This is more about opening the world of access to different information that will help them participate. And if you don't mind, June Tierney had a wonderful way of describing why this is important. That, you know, when you were talking about through EPSB, how what a difference it will make for people to be able to search the database of
Right,
court
right,
orders.
the equalizing effect of that, and I do think that is a very important thing for the community to hear, because the way I like to think of it is, it's the difference from being able to ride a stagecoach in the 19th century to get to your destination, and being handed keys to a car and a GPS unit in order to go wherever you want to go with information of a breadth and depth that you've never had before. And so that enables ordinary citizens who cannot afford to retain counsel to build a case using many of the same information blocks and models of process that counsel have, because they have training and because they have Westlaw, or LexisNexis. So this is you know, because we say it so often, it sounds like it's just one thing, but it's really a transformative moment in how the board interacts with the public, but more importantly, how the public is able to avail itself of the trove of information that the board has in order for the public to tailor that information to its own pursuits in proceedings before the board.
Sounds good. The
And
this
another one
language-
is that transcripts, that's a big change too.
But yes, that one is, that's one of the success stories. I'm glad you pointed it out, Board Member Cheney, because this is something where I think the board already goes above and beyond what other agencies do and what courts do for that matter, because this is something that people have to pay for. And what you can get out of a transcript, which we make available free of charge, it's available to people 24/7, so they can look at it whenever it's convenient for them. And this is especially helpful to people who are perhaps not able to get to a hearing or not able to monitor the hearing when it's being streamed or something. It enables them to see not just what was said in the testimony, but having access to these transcripts allows them to see what was said in other prior proceedings that are similar in nature, for instance. It also helps them see examples of how people with skills to develop lines of cross-examination develop those lines, so that you can try to use some of those approaches yourself. So it's a multi-layered tool that seems very simple, because all we're saying is we're making a transcript available, but it really opens a lot of doors for people to participate both on a pro se basis, and also if they just want to do that as a friend of the board, I mean, like a friend of the court.
I want to compliment the board on this, because this is a big change from when I started. My understanding was the transcripts were only available if you contacted the stenographer's company and paid like $6 a page or something to get it, or I don't know, some
Right.
outrageous fee. And that's how they were making their money. So you obviously must have renegotiated
Yeah.
that contract with them to make that transcript publicly available to
Yes.
anyone, and that is a huge change.
Yes.
Any changes here? Okay, thank you. Page 7, recommendations in this section involve changes to the board's procedures or processes, including those related to how board personnel provide procedural guidance to citizens. And these recommendations will help citizens understand how they can participate in board proceedings.
So if you think of the last two sections, the first one was essentially providing better tools for people. The second one, which is the one we just looked at, is more about providing better material to them. And this one is about help, so that enlisting the hearing officers to act, basically provide procedural guidance. By loosening the ex parte rule, would be one example. The last one, having them act more often as mediators, for example, by conducting a status conference partway through the case. And then basically, generally, acting from the bench to help explain or guide somebody when they may be lost if they're not a lawyer. So it's more about bringing in us, for one, to help people on first one was the one that, you asked about earlier, this first bullet is your recommendation, Senator Lyons.
Right, so, and then the question is, to what extent such a Bill Back or other advocate office would engage with how many interveners at what
Yeah.
level? I mean, it's a huge question.
This is a huge question, and frankly, you know, having been on 2 citing commission efforts over the last 3 years, you know, I don't see how to get through this one, and you know, you can picture, well, can I talk about, this docket,
7970?
7970?
You want to talk about it historically?
I think so. What I want to talk about is the different interests of the parties and how that played out for us. Is that?
I'm only hesitating because
Yeah.
I know there's another docket that's open.
Yeah.
That could have an impact
Okay, so I won't use, I'll just use
General
hypothetical.
lines.
I'll use hypothetical.
Just a hypothetical.
Make up
So,
an example.
I'll make up an example. You have a project that a lot of people are opposed to, and you hear about the public comment from that. They often coalesce and, you know, agree that they oppose this project, and they do things together in a lot of ways. And then, as you get into it, you find that their interests diverge, and they diverge in many different places. A property owner might be upset about a project different than ratepayer concern, and those may be very different. A property owner may have adverse issues about a project relative to another property owner. Like, I want it to go on your property, not mine. No, I want it to go on your property, not mine. And I try and think about, okay, so who are you funding? And if you think it's a group and you fund them in one piece, then when things start to diverge or fall apart through the process, somebody says, I don't agree with them anymore on these issues, I want intervenor funding to advance these issues in this way. And I don't see any end to that or how to do that. The public advocate and consumer advocacy offices of the department need to represent the interests of the state of Vermont. We need to, I agree with everything in here that says evaluate comments, listen to them, respond to them, address them. But the idea that you will somehow fund, and particularly with the public advocate office mentioned here as a problem, that you will fund interveners.
A public advocate office. I
I get
noticed they
it.
put the word A in there, that,
Yeah,
that's.
at the very least, on this one, I would end the sentence after or other forms of funding. But I don't see how, I mean, again, we have addressed this multiple times in multiple venues and not come to a solution on this. And even the solutions where the board decides afterwards who is entitled to funding based on whether they contributed significantly to the proceeding. I mean, that's really up to the board as to whether they wish to do that or not, but I don't see how that works.
So who makes a decision about intervenor status?
Intervenor status?
Who can be an intervenor?
Board.
The board makes that decision. So if the board makes a decision that this individual or this group is an intervenor, then wouldn't that be appropriate for some support?
It could be many interveners in some cases.
Right.
We're not just talking about one or two.
Right.
How do you decide who,
With,
and how much?
with different perspectives.
Yep,
For how
and
long?
how much money?
And for how long?
Right, somebody's got a whole list of issues, and another intervener only has one or two. Do
And
you
it could go on for
adjust the
years.
funding?
So you're telling me that this is a simple issue?
Yes, exactly, Madam Chair.
And,
It's certainly something that has been debated in the legislature.
from time to time, has it ever been debated in depth?
I think in my committee, we took it up in a fair amount of detail until we got
Overwhelmed?
tsunamied, yeah, with the many paths that it could go down, and there was no real way to channel a fair access to publicly funded entertainment.
So there's no way to establish criteria or conditions for
That was
interview?
acceptable to everybody?
Yeah.
Pretty hard. I think all of us on the surface would say it's a pretty good idea.
Mhm.
But when you try to figure out just, how you do it, and how long does it last for? How much is it going to cost the ratepayer?
Yeah,
And who gets access to it, and who gets closed out? And how many interveners for how many different cases will you be equipped to provide?
Judge Mello, any comments?
Well, I'm troubled by this one too. If the department is the agency that we all rely on to advocate the public interest, and the board is the agency we all rely on to determine what the public interest is. And there are always going to be members of the public who agree with that assessment entirely, and there are going to be those who disagree with it entirely. It seems counterintuitive to have a system in place where we're providing funding to people who are arguing positions that those in authority have deemed to be not in the best interest of the public. So I think it would be best to just leave it alone, leave it like this, that a party may petition the board to build a utility or utilities to raise funds, to authorize a party to hire an expert or something like that, and leave it up to the board whether it thinks it's prudent to do that or not. In other words, give people the opportunity to ask the board, but leave it up to the board to decide whether to do it or not. Otherwise, I like the representative and the commissioner said, I don't know where you would draw the line, where it would end.
So let me ask,
The board's-
sorry, go ahead.
Just leave it to the board's discretion.
Do you already have that authority? Isn't there something where people,
Telecommunications?
where people can petition for the board to grant intervenor funding? of some
There
sort?
is specific language about this in the realm of telecommunications.
Right.
Okay.
Otherwise, what the board is guided by is the common law.
Mhm.
And in the common law, generally, the board certainly follows the American rule, which is litigators bear their own expenses. But in some limited circumstances, the board, like courts, has approved that one party be ordered to pay another party's costs because there was wrongdoing in the case, for instance, or, there was some circumstance that justifies it. It has not been the norm, and I would not put intervenor funding in that category, because intervenor funding really posits that a decision is made that somebody's position is worthy of being carried forward at the expense of either the public purse, or in this case, if it's a utility ratepayer purse. And there are jurisdictions that do that, there's no question. But that's generally established statutorily, and to my knowledge, that's not been established here. The only thing we have that comes close to that is the build-back authority that the state agencies exercise, subject to review by the board and approval. It's a big step, and to my mind, it begins to go beyond ease of participation and really has more to do with how you're setting up certain chairs on the bench for the case.
So if, in the 248A section, there is the option for municipalities to have some funding for their experts, and that's just for telecom. Perhaps we could suggest that the legislature consider expanding the municipal options for other than telecom, and that for me would be a step in the right direction to.
I agree with that.
Okay.
I agree with that.
So could we do that in place of what is currently here?
I would, I'm uncomfortable with it because of the implications, for ratepayer impact.
Well,
In a big case that could go on for years and have it be billed back, to ratepayers, I think that's an enormous policy decision with, consequences for the average Vermonter.
well, I agree with you, and that would be exactly why it would have to go through the legislative process for it to be considered. I mean, so, right now, it's
Right,
telecommunications.
I'm just saying as a member of the working group,
Yeah,
I don't.
okay. Okay, so we've got two okay with it, and we've got one against it, and Tony and Chris, you got a.
I'm actually okay with it if it is still triple asterisk as a recommendation to the legislature. And I'm only comfortable with it because I think that the board is capable of making that decision about whether this is going to be adverse to ratepayers. They can do the balance, but that's my reaction.
But does that recommendation actually allow that expression?
Yes, I mean, if it follows the telecommunications thing, it does. It allows for the board to decide. That's my understanding, and that's how I would, if it, June, I
Still
don't
in the
know if
hands
you.
of the board.
So I can live with that better than where we were.
So Senator, can I excuse myself? I've gone through the rest of the document. I didn't have any particular comments on the rest of it.
All right, thank you, Judge, thank you, Bob.
Thank you, Judge.
Very
Thank you all
helpful.
very much.
Bye.
Can I change the seat? Seated.
What would happen if we said?
Can I go to the rest?
It says like, placing this recommendation to the board of the mayor is.
Hey, where is it?
Yeah.
Where is it?
The restroom, right?
Oh, I forgot.
You do have another 5 minutes.
That's okay. I think
like- I like
I think the
the-
rest is, that was probably the hardest one.
Yeah.
Well, I think that on page 8, the asterisk at the bottom of that last bullet, that does go a long way to providing support for individuals, so, yeah. All right. Good. So we've changed that one. Do you want to take a break for 5 minutes?
Looks like some people already have.
No, it's for John.
Huh?
Yeah, let's
for
forge
John.
on.
For John, all right.
It's getting late. Or at least, well, maybe not really, just feels like.
No, it's daylight savings. Okay, so.
9.5 hours of daylight.
Yeah, so anything else on, page 7? We've modified that one.
I do have one question for Margaret and perhaps June. The 5th bullet up or 5th bullet down? Loosen the board's ex parte rule, is that really required to loosen it, or is it just interpretation
It's loosened.
It's loosened,
It
okay.
needs to be changed.
Leave it the way it is, thank you.
That's a big help.
Yeah.
Okay.
Yeah.
Anything else? So I'm also aware of the comments that we received regarding Act 250 and that the Natural Resources Board is different from the Public Service Board in some respects, and that there's another step to get to the court, to the E-court, where there is not another step at the Public Service Board. But reading all of the yellow that we have, I think fits nicely.
Well, big proportion of the document.
And the last, on page 8, that's great.
It is, I actually have
Who did
a
that?
a suggestion. I think that was one of our, I think that is important. I would recommend a little language change here. Assign responsibility and resources for, I would say, direct enforcement by the department. The rest of this stays the same. And then at the end, suggest that we add appeals of department actions can be taken to the board.
New sentence?
Yeah.
Would be.
Maybe take them. Okay. Anything on page 8? Page 9. Currently, there's widespread confusion among citizens about the difference between the PSB and the DPSD. I would say, I almost didn't read it right. This confusion makes it more difficult for citizens to understand the board's processes and how they can participate in them. So we have a recommendation.
So just as, there's no objection to this recommendation, but I do have a somewhat funny but somewhat contorted story about, we used to call ourselves the Department of Public Service to distinguish from the Public Service Board. Not that that really helped much, but at least it was a different order. And then, during one cabinet meeting somewhere along the line, somebody said they get confused between the Department of Public Service and Department of Public Safety.
I do.
Right, so they decided to.
I see DPS and I think,
Right, so they decided to change us to the Public Service Department, which made it more confusing with the board, but
Because then the initials
are
were.
almost exactly the same.
And D and B.
Yeah, you have to say B as
yeah.
in boy and D as in dog. And I started calling us the Department of Public Service Department, so I had a good part of people fans because I didn't know what to do. So yes, something here would be good.
So, yeah, you're the dogs, we're the boys.
Yeah.
that would be a simple thing. Who's the dog? Okay, that's a good one. Anything else you want under that? No. These recommendations will allow policymakers to assess the board's progress in improving the ease of citizen participation, and then we've got 2 bullets on that.
I just thought of it as something in that in that sentence, and that is, it's not just policymakers who would be able to assess, it would allow simple assessment, it would allow, even, see what I'm saying?
The public.
Yeah, so we'll allow assessment of the board's
Right.
progress,
Anybody.
anyone.
Okay.
Okay,
Okay.
so my only comment on the second bullet and I'll make this pitch, but I don't think it'll go anywhere, because, this type of public assistance officer needs to be at the board. And I know they say that it needs to be at the department, but the truth of the matter is that we don't have the information at the department. We are often asking the very same information of the board that the public would be asking, and we don't have the ability to get that information out from the clerk any easier than anyone else does at the moment.
So I could easily counter by saying this public
Please do.
assistance officer position should be at the department, but I won't, because I actually think that that's, this really puts the question a year from now, after we've had an opportunity to see indeed if it's even needed anymore.
Right, I mean, the loosening of the ex parte stuff may actually solve
Yeah, I
a
mean,
bunch of
after, if you take all these steps, there are a lot of them, and there's 10 pages of them. And taken together, I believe or I hope that the problem will really shrink, and the need for this kind of position, I hope will be able to be provided by existing personnel.
Okay.
And because I'm hoping, and not just hoping, we would be able to assess in a year, through real data, whether this is still needed. And then, if it is, then we could have that debate where it should be.
Well, you can have it with somebody. But yes, that's fine, never do today what we can put off till tomorrow, I'm good with
Can I
that.
ask a stupid question? I mean, not, will there be enough experience with all the possible changes that we'll have information
So
in
maybe
a year?
that's a good question.
I mean, I don't know. I don't know how many significant cases are gonna be
Well,
coming
you could
before
have
you.
it in 2 years.
Ongoing
Yeah.
for 3 years, something like
Yeah, you could
that.
have an annual report
Uh-huh.
for a limited amount of time, not
Right.
forever.
I would say yearly reports for the next 3 years.
Mhm.
Let's just put that in.
That's a good point. I mean, you do need, you're turning a ship, so it might take more than 12 months.
Okay. Page 11, we've already been through, so we won't beat that dead horse. So we're finished with that section, and I will make a suggestion that I wanna finish up our conversation, and then we'll see if the folks around the room wanna have a minute comment. The question is, these are the recommendations, and in addition to the recommendations, we're going to be attaching all the comments, the testimony, the minutes. What else? That's it. And, so, we probably should have some kind of a second sheet that lists, members and, staff who have been charged.
Yes, I agree. Credit,
Anything else that you want? Or we only ask for recommendations, we don't thank heavens.
You have a report.
Yeah, we don't want a full report, that's,
There's a lot here.
no kidding.
And you can give the report to the legislature.
That's what I'm afraid of. I'll be dragging some people along with me.
Well, one of them won't be me.
You never know.
I do know.
You're still a citizen. Citizen participation is important.
I'll be on my back line
Time
if
is
you
done.
need me.
All right, so,
Okay. I gave away all my suits.
you can roll that. Okay, so,
Much to
any
know about
other
it.
thoughts from us?
No, but thank you for your leadership.
Yeah.
We're not done yet. We're gonna have to, we're going around the room
No, I
here.
know that.
Good. So, comments from folks in the room? Yes, sir. and please state your name for the record, and then,
Charles Larkin.
yep.
I thought that that returning the VIT, I think, is an essential, very essential point. That would automatically eliminate any of these phone calls or letting them. There's no good having somebody on the phone they can listen, and they can't interact. It's useless. So I'm looking forward to seeing that restored. It never should have gotten informed.
Well, that's a huge step, and it's gonna require some action on the part of the legislature to
I
make it
know.
happen.
And a lot of money.
They got rid of it, so now they did it.
Yeah,
I think we only got rid of it because it was a budget cut.
it was a budget cut.
And yet there was all this investment.
Yeah.
Lots of them.
Yeah.
The other thing is that MOU business. Yes, it can be one at the very end, but then there can be one very in the beginning, such that there are no opportunities to have any cross-examination of the parties, because the only two parties are the department and the utility, and they've already signed off. They were in agreement. They're hooked at the hip there. And so the consumers and any interested citizens don't have any opportunity to see that and understand it or any testimony on it. So I think that's a very important issue. And the last thing I have is that disruption business. I think the disruption.
Right.
Sure, disruption is a great problem if it occurs. We've only had, my knowledge, one in the last 30 years, if not 40. Looking back at my experience with the department of 35 years experience with it. But it would seem to me that that's what you call the cops in and put the disruptors away. And then those who don't disrupt can then stay. It might take a little more work. Rather than just closing the doors, just grab the idiots and put them away. And then I think that's the approach that should be taken. And the robocalls, they do express something. Citizens have, what used to sell on postcards they'd have from these organizations, now they make phone calls, they go to the internet and they press the go button and they were on the list. But if you get 250 of them, that's got to have some value. I think you're right about you ought to respond to them, but you should perhaps have 3 or 4 responses. I know when I sent to Leahy, sometimes I get a really long thought-out thing, and sometimes I get this, thank you. And so it depends on the power of what you've received. If it's some kind of just bland robocalls, give them a bland answer, thank you very much. Individually, they've got something back. They know they've been responded to. And then you can proceed to find out what those problems were in that group. And you can address that as one response to 250 people is, they complained about this. Other than that, I also congratulate 2 people in a row. I think it's a very well done job.
Thank you.
Addressed many of the issues that I saw while I served with the department.
Well, now, let's hope that it's all in one place. Okay.
Keith Ballock, Sheffield. I'm just curious, I know this is going to, recommendations are going to go to the legislature. Is there a timeline for them to act on this? Or is this, because I've seen these things go on for years, so there's no timeline?
There's no timeline. I mean, our task was simply to make recommendations, and beyond that, that's it. So we will get this back to the legislature, and then I would think that the committees of jurisdiction will take testimony. I mean, I'll probably go in.
I don't want to speak for the board, but there are some recommendations here that affect the department.
I haven't gotten there yet.
Oh, sorry.
Okay, go
And
ahead.
I was just going to say, we'll do them. We don't need time, and we'll just start doing them.
Yeah, the only reason I asked is
Right.
because you've seen how long these things drag on.
Yeah, once or
As far as
twice.
anything
Yeah.
being done on energy siting, this has been back burner, seemed like, for years.
Well,
So,
So I would imagine, Madam Chair,
you're in it first,
Yeah.
and then Margaret.
I think the charge is that you're going to present this to the Senate Natural Resources and House Natural Resources Committee.
And finance.
And And had I been returning to the State House and had I retained the chairmanship of the House Natural Resources and Energy Committee, much to the horror of some people and probably to the delight of some others, I would assure you that I would take this document that was presented to us and immediately put it into a committee bill. And that would make that the centerpiece of the bill, and then folks would come in and you'd add the intervenor funding, or you'd research that and any of the other issues. But that would, I see the document that we're going to present as being the centerpiece of legislation. I doubt very highly that you're going to see two committees say thank you very much and never hear about this.
So it won't sit on the wall, in other words?
It will,
It
well,
would not sit on the wall.
First, a bill will have to be
Right,
introduced,
sure.
and
I
at
would
least
do
there's
it
one
as a committee.
legislator who's currently here and also in the Senate, so maybe that legislator will, have a bill drafted.
And I also think your question is complex. There are a couple of layers to it too, because some of this will require action by the legislature, and other parts of it are essentially educational about letting people know what's already underway, and that won't require any action. So I think it'll be important for whatever legislation is introduced to pull out the things that actually require action. I think that one benefit of this document is that it tells people how things are changing and also what's available to them, but it doesn't actually require action. So that'll need to be pulled out.
Thank you.
Elizabeth Cooper. So I'm not quite sure I understand what the status of this is now. And is it after you put in the things that you've talked about today, is that going to be the final version?
Probably.
And will you review it again?
Yeah, we've got to come back in 2 weeks, and we'll review the final document, and then we'll make a vote. And
So the other thing is we need to add an overall introduction.
right,
So that will need to be reviewed first. And we've got some edits we need to make.
right. So there are changes that we've made today. We'll have some overarching paragraph. It won't be long, and then we'll bring it back here. We'll review it, make any final edits, vote on it,
Okay.
and then it will go by December 15th to the legislature.
Okay.
And this committee exists until January 15th, but I.
Oh, good, they get another 2 weeks.
You get an experience.
So I just had one comment, and that is on page 2 at the bottom, the last bullet, about hold at least one public hearing in cases with significant public interest. And I just want to say from my observance and also my participation that in particular with, for instance, say a smaller solar case, you don't know if there's going to be a public hearing, but if there's a big group of people who file for intervenor status, and it may be that size project does not require a hearing, so that might be a case where this would come into question. And so it could be determined that it's significant because you've had a big group of people apply for intervenor status.
June, does that fit with?
Yes, I think
Legal.
also possibly many comments that are filed, even if we don't have a lot of people asking for intervention. If we get a big amount of comments on a small project, that might be an indicator that it has a significant amount of public interest, and therefore warrants a public hearing, even though by statute the hearing is not required.
Right.
That does fit that template.
Okay,
So, yeah.
thank you, that's a good example.
So that would be the long delayed answer to Representative Klein's question, is there any such animal?
Yes, ma'am.
Carol Irons. I don't see, I don't have that paper, but I haven't heard anything in any of these recommendations that addresses the definition of public good. And I've been involved with this for years in terms of industrial wind, as some of you know. And all the decisions always come down, it seems to me, in any of these regulatory hearings, in favor of corporate good, which is defined as public good in the result of it. And those who have very serious objections and hire really qualified experts and all, it's kind of, in the end, summarily dismissed because it's not in the public good, but what the corporation's asking for meets the public good. But there's no definition of that phrase ever. And it's one of the root causes of the anger out there, because it seems to be, it's very one-sided. And I realize some of you don't agree with that, but that's the perception that a lot of us have struggled with for years. And I think if by statute they would define that really clearly, then we might all be a little closer to seeing what's really going on.
So I will share with you, one of the first questions I asked my legislative counsel in the State House was the question of, where in statute is public good defined? And it is not. And I wish that he were here, maybe I'll ask June to comment on it, because she's got the
Her
legal
hair just
background.
curled.
Can you, just to talk a little bit about and I will say, before we go there, I mean, that is not part of our charge, and we did talk about that very early on. So our charge is to look at easing citizen participation. The question of whether or not we should define public good in statute is debatable. It's a debatable question from a lot of different perspectives. So, June, do you want to comment on that? And I will not put you on the spot if you say no. I mean, you don't have to. I know it's an interesting topic.
It's not that I do or do not want to, it's that I'm not sure there's anything meaningful that I can say that will assuage your concerns. I can only speak to it as a citizen, just as you do. And from that perspective, the public good, I suppose, has to entail a broad definition of many interests, and what one thing will serve many interests as opposed to a specific interest. But I don't think I am specially positioned to inform this question. I think it is a result, not something we define. It's something that emerges if many things go right in public policy. And necessarily a decisional entity like the board is charged with using its discretion and its judgment and its good faith in arriving at a result that is deemed to be in the public good. It's a lot of words and nothing specific. That's the best I can do.
So let me, Jeff, go ahead.
Being as how, this is Jeff Commons, and I am the public advocate. I've spent 26 years plus thinking every day about that exact question. What is the public good in connection with this petition or this proposal? What is the public good? I don't know that it's possible to define it because there are so many different views about what it is. But I can tell you the things that I look at in trying to figure that out in every case. Probably the first one is the Green Books. There is not a definition of public good, but there are certainly goals and legislative policies, state policies set out in there. Section 202 something defines what we want in, for example, an electric system. Safe, adequate, reliable, affordable, sustainable, et cetera, et cetera. It's not going to tell you the answer on any particular petition, but it tells you what you got to think about. And I take that as an indicator of where I should be looking for the public good, because that is what was enacted by my clients, the public's elected representatives. And it's not going to be whatever answer I come up with, or the commissioner, or the department, the board, it's not going to make everybody happy. I don't know that we're ever going to find any definition of public good or any outcome in any case that's going to make everybody happy. And that's kind of the messy business of being a democracy. But that's, and besides the green books, I mean, there is a large body of law about utility regulation. I look at that, I look at prior board orders, I hear what the executive elected by my clients has in the way of policies. So we don't make it up out of whole cloth. We have some direction. But we don't have a cookbook. We don't have, this is how you steps 1, 2, 3, and 4, and bingo, there's the public good. I don't know that that's possible. But I will tell you that I struggle with that every day.
And maybe I could just add that Jeff can attest to this. Much like the senator when she asked, where's the definition of public good in the statutes? I came into this job and it had to be, if not the first question. First question was probably, where's my office? Second question was, how do we determine what's in the public good? And we all sat down and got educated about that, much like Jeff just described to you. And I know that these people who are many decades of work and some fairly new, but all with the commitment to do the best they can for the citizens of Vermont. And they do it every day. And it's not a cookbook, and it definitely does not make everybody happy. There's one case that I can think of where everybody was like, this is great, and no varying opinions. And we try, and as this report is describing, we will do a better job of describing how we consider and respond to public comment, including objections or individual concerns that don't make it over that threshold, but it is something we do take seriously, although don't have a formula for.
So before we go on, I'm going to take a 5-minute break, and then we'll come back and we'll finish. I need to take a break.
Very good.
I'm going to do that.
And Madam Chair, I actually need to go, but I think we're good. I'm good.
That's debatable.
Right. Good point.
No.
I'm sorry.
Are you leaving at 3?
Yeah, I
Okay.
actually.
I'm going to take a 5-minute break, so that's fine.
I know, but I'm sure you'll send them to me or I could.
They'll never do that.
No,
They
and
just
they can
send
be,
it back
they can come up with anything they want, regardless of other people, because whatever they come up with, even if it benefits the corporation or not the community.
Unless you think that's a stupid idea.
Yeah.
I worked 35 years there. I worked there for 35 years. Well, I was still
What I'm going to ask for, instead of continuing the conversation on public good, which was an excellent question, and I just decided that we should get the law school to do a symposium on that for us. We could all go and listen and learn. And any other comments about the recommendations?
I do.
Go ahead.
Oh, he's-
Yeah, he had his hand up.
You had your hand up?
Yeah, I mean, I did want to comment briefly to continue on public good, but I consider that you're not going to allow me to, right?
Brief, go ahead, give it a minute. Can you give me your name?
Yeah, for the record, Austin Davis, Policy and Communications Coordinator for 350 Vermont. I think for a lot of the volunteers in my organization, that's something of concern as well. And I think, I certainly don't have the legal acumen of many people in this room, but with the quasi-judicial nature of the board, I think that, that a lot is built off past precedent, and that's what they see. And I don't necessarily believe that with the changing grid we have and the challenges we're facing with our grid and transitioning our energy system to renewable resources, that we can really fall back on our decisive decisions, because those are decisions built when the goal of expanding public infrastructure was very different. We're looking to build efficiencies, we're looking to build distributed generation, we're looking for a high rate of efficacy now. And when a lot of those previous decisions which guide the board were made, we were just simply trying to electrify everybody. We were just simply trying to get service to everybody. And so I think a lot of the volunteers within my organization now, they see decisions being made off the idea of just getting everybody access, but really it's not the goal that they see in mind. So, I think there's the upside of having a statutory change to really solidify what public good is in our new grid. And I'll leave it at that. I could probably go on for a long time. But outside of that, I would just like to echo the comments of Judge Mello on evidentiary hearings. It's no secret that my organization had a lot to do with those evidentiary hearings that were canceled. And I would worry about potentially closing doors to the public, although I don't think it needs to be discussed much further. And then I also would just like again to go to the robocalls discussion. I don't think the term robocalls certainly does it justice. Robocalls are kind of indicative of one individual calling many and pushing an opinion. These are tools to allow individuals to reach out to their legislators, to their elected officials, to their appointed officials, and express a certain opinion. They may be carbon copies of each other, but that doesn't, mean that they're any less indicative of that citizen's opinion. And like I said, as someone who's on both sides of those, and someone who's handled constituent correspondence within this state from Vermonters and seen a lot of those, I would say that it's very, very easy to respond to those, given the tools that are handed to the administration, that the administration currently uses. And I think that they warrant responses generally. Outside of that, I don't think I have too much to fully respond on. So, thank you.
So thank you all for your comments, for being here, and very helpful. So, Steve?
I'm the last one.
Yeah.
Try to be organized here. Briefly on the public good question, 2 sentences on that. To the degree that the goals in both energy and telecommunications are made more specific in statute, and then I noticed that under 226A and B, the board is required to confirm consistency with those goals and or the plan, and or offer a good reason why not. And that is in effect possibly the most powerful tool you have between the legislature and the board to define and illuminate the definition of public good.
It's 4 sentences.
I'm sorry.
Just kidding.
Can I take 2 back?
No. We got it.
One item on page 7, continue to issue decisions on requests for extension of time sooner so citizens know whether to continue the draft or filing. Unfortunately, as a great example of that, somebody requested an extension on some briefs, and I didn't know about it until Charlie and I had spent 2 days of our holiday weekend adhering to the old deadline, whereas if I had gotten an email, it would have simplified that. The department gets quicker access to information than that's related to the closed hearings, open hearings. I would like to just call a little more attention to that, because the way my understanding of the protective agreements is that it's the key word is agreement. That the board hasn't made a decision on confidentiality. That's really subject to the courts. And this is an area of difficulty in participation, because utilities and even the department has cast a wider and wider blanket of confidentiality on the very information the public needs in order to participate meaningfully in 10-year telecom plan, in dockets related to telecommunications. I also want to point out that Jeff Commons is the public advocate, except for telecommunications, by his own admission. And so we are currently lacking, and it's partially to do with H117X41 that blurred the line. Jim Porter thinks he's the advocate, but he doesn't do advocacy. But to the degree the board can help to clarify and/or form some good board decisions and have them tested and affirmed in the courts, that would provide good, clear guidance. And I think I might pursue that avenue in order to make clear what is and isn't proper grounds for closing a hearing. Because we cannot define and strengthen and participate in our telecommunications future if we can't know where anything is. As an example that was requested by Ms. Tierney, there was no public hearing in the Fairpoint service quality docket, which ended up being closed by an MOU with only the department and the company participating. That's one that clearly needed a public hearing for the broader range of issues, and it's going to have to get dealt with in a different docket. There's no mention, virtually no mention in this draft, of the role of the independent public advocate. And I have provided a couple of case board precedent decisions which lay out in the board's own language its authority to appoint independent public advocates. And the reason I point to that is that many of the questions around funding independent parties, diversity of them, those can be potentially resolved through the use of an independent public advocate who is a professional, trusted, nonpartisan attorney who can focus those various. You still can't focus when there's conflicting interests, but can bring all the common interests together through one efficient judicial economy of a paid public advocate. Anywhere that there's a conflict between MOUs, contracts, incentive regulation plans, there needs to be an independent public advocate. Part of the biggest impediment to citizen participation is cynicism, discouragement, mistrust. And you really need to keep that front and center in how you design your solutions, because to the degree folks believe that the company will always win, there's no incentive to participate. I believe, again, on the public hearings, an MOU might trigger a new public hearing where the case already had its public hearing, and then it starts to be settled by an MOU. That might need to trigger an additional public hearing, because in effect, or even appointment of an independent public advocate, to repeat myself.
So, yeah, I think that your comments are well taken, understanding that some of the detail that you're getting into is the kind of detail that I would think the legislature will be very interested in, sort of flushes out more of the issue.
I think perhaps the way we've redrafted that recommendation.
Yeah, I think that'll help.
Yes.
I trust John.
And on the public advocate, the independent public advocate piece, thank you, we're all set.
Okay.
But I would make a suggestion, after listening to Steve, I'm going to go back to page 7 and question that continue to issue, these are things you're already doing, and I'm going to ask Margaret a question.
Yeah.
Is it continue to issue decisions on request?
Well, I think what, basically
And-
Steve has identified an issue that we've identified too.
So would you add in there extension of time sooner and on request notify citizens? I mean, is there something you could put in there that citizens would be notified if there was an extension?
I think this is a part of this thing.
Yeah, but the thing, it went out on a Thursday of a holiday weekend, so the mail didn't get to us until after we had.
Well, e-board is gonna take care of that.
Right.
EPSB.
Only if I forfeit my right to paper notice.
Well, that's your choice.
No,
I think generally speaking, it is an issue,
Yeah.
and which is, and we are aware of it, which is why we wrote something to try to get at it, and there may be other ways to get at it, but we are aware of the problem.
thank you.
Okay, and then on the question of the telecom advocate, is there something you want to say in here or not? I mean, it's been my assumption all along that whatever we're saying, we're being inclusive of all of the issues that the board and the department discussed. The only question is, on page 10, last bullet, public assistance officer position, the choice is board or department. Do you want to add independent, or is that something not,
Where are you?
on page 10? Whether or not there's a public assistance officer position. I mean, that's not the advocate, so.
Yeah.
I think the independent advocate question will be brought up relative to a lot of the other issues that.
Yeah, it's not in our charge.
Yeah. Unfortunately. It'll be fun. Okay. All right. So, I would say, that we'll make the adjustments. Andrea? And in consultation with members, if there are any questions about wording.
Well, I would like to discuss that briefly.
Go ahead.
Because right now, I've taken notes of what might be in an introduction, because I think that, like, by implication, we're offering to draft that introduction. And
Not yet. I haven't gotten to the introduction yet.
Oh, I thought that's
I'm
what you were
only,
talking about.
no, I'm talking about the changes that we've made in the body.
Oh, yeah, we'll do that.
Okay. Now, introduction. So, now, are there any volunteers for writing the introduction?
I'll volunteer for it.
And then we will, can we send that out ahead of time?
I think we should send that
I mean, I don't like doing business in between meetings,
No,
but
this is an
the kind
important
of
one.
thing-
I
this is
think what
something
we should do is we should send out a redlined draft. I'll volunteer to write it.
And then we will, can we send that out ahead of time?
I think we should send it out.
I mean, I don't like doing business in between
No,
meetings, but
this
this
is
is
an
the kind
important
of
one.
thing,
I
this is
think what
something
we should do is we should send out a redlined draft, a new version that shows the changes that were discussed today, and a which will be entirely new. And do that well in advance so people can come prepared either to vote or to.
Right. We can edit the introduction, and I think we'll be making minimal edits on the recommendations.
Yeah, I mean,
so.
but I think they should be redlined so people can see exactly
Absolutely.
what they are. And then, so, in the introduction, obviously, there would be a summary of what our charge was, who participated, and what our process was, basically a short history, very short. And then, this is in no particular order, but I think it's important to point out what, was raised about what are the next steps, to point out that many of these recommendations don't require legislative action, even though we've asterisked those that do, remind people that many of these are underway. And then in relation to that, point out the relative importance of some of them. Highlight, for example, things that may seem purely bureaucratic actually will make a substantive difference. And EPSB is one of the things I think we should highlight. So that's what came to my mind, and I'd like suggestions for what else should be in there.
Well, sounds good.
Okay.
Is there anything else you want to put in there, Tony?
Well, I'll send you around early, so if you think of something more, we could add it. But I think, or would you rather do that kind of thing, maybe we should do it in our
I think sending it out ahead of time as a kind of a rough draft, rough final draft, and then we'll fine tune it. But the red line recommendations, I think, should be pretty solid.
Okay.
We've done that.
And then as far as attachments to the recommendations, you had mentioned earlier
The minutes,
the minutes,
and the comments that we've received.
written comments.
Yeah.
And the other submissions.
No, you've got a packet.
What about the PowerPoints,
Yes.
Yes.
the presentations that we
Yes.
okay.
Yeah, we've got quite a bit. So the recommendations and the introduction they could be separated
Mhm.
out from that, and then we could provide one copy of all the information to each of the committees. You know, one copy of the whole packet, and then anyone who's requesting recommendations, I think. We don't wanna cut down too many trees, that's all.
Right. I see the introduction as being half a page,
Yeah, me
maybe a
too.
page. Mhm.
The attachments will just be one
Yeah.
copy for the committee, and if they wanna.
I would suggest that for our meeting, next meeting, that we not print out all the attachments. We don't need to see those.
We have those.
Yeah.
Okay. Anything else?
Next meeting,
December, shoot.
I'm not available the first.
December 1st is 2 weeks from today, which is also right after Thanksgiving.
I
Well, not
propose
right.
the
I have a
8th.
rules meeting that day, so I'm happy.
I would propose the 8th.
Unfortunately, we have technical hearings all day on the 8th.
Or the 7th.
I can't be here, I'm teaching.
Could we do it earlier than the 1st that week, for example, the 29th? Or
I know that my schedule is absolutely full that week. I have this in, but, the 8th, you cannot do.
No, no one at the board can be here.
What about the 6th, the afternoon of the 6th,
That would be all right.
Tuesday?
That's fine.
I think it's okay with me, I don't have anything with me, so
I'll circulate an email to all the
Yeah.
members.
Okay.
In the afternoon or morning?
1 o'clock. I know I've got an obligation in the morning.
The minutes from last meeting. The minutes from last meeting.
Oh, do I have a motion on the minutes?
Approve the minutes of November 17th.
November
Third.
Sorry, November 3rd. November 3rd. Today's November 2nd, I apologize.
Second.
All right, any additions or corrections? All those in favor?
Aye.
Aye.
Opposed? Good. So I just want to say thank you again to Andrea for your
Yes, thank you.
support for it. Good. And next time will be our last meeting, but we need to make sure that we have everyone.
Yeah, I'll send
So
an
the emails, of
email
course.
just right when I get upstairs.
Okay,
Sounds good.
all right, good. Thank you.
You know,